Good evening. I am Sedalia Lobo, advocate, and it is my privilege to serve as your compare this evening. On behalf of the Goa State Legal Services Authority, under the aegis of NALSA, and the Goa High Court Bar Association, welcome to this series of workshops on forensic evidence. Respected judges, senior advocates, junior members of the bar, our distinguished guests, and participants who have joined us both in person and virtually. In keeping with tradition, let us begin the session with the NALSA theme song. Now, while the original version of the NALSA theme song is in Hindi language, for the audience today, the translated version in Konkani language will be played. I request the technical team to please play the song.
सगळ्यां खातीर मळब न्यायाचे सगळ्यां खातीर अनन्यायाचो सगळ्यां खातीर विश्वास न्यायाचो सगळ्यां खातीर आमच्या ह्या भारत देशाचेर हक्क आमचोय बी आसा न्यायाच्या ह्या आसऱ्याचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा
अशें समजू नाकात दुखणें आमचें खंयच आयकचें ना आतां न्यायालय स्वता चावडे मेरेन येतलें
निराधारांक न्याय मेळटलो दुखेस्तांकय बी न्याय मेळटलो दिनदुबळ्यांकय बी न्याय मेळटलो देशाचेर हक्क आमचोय बी आसा उमेदीच्या ह्या फुलबागेचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा मुठभर मळबाचेर हक्क आमचोय बी आसा
गरीब आणि दुबळ्यांक फुकट तसोच घटमूट कायद्याचो पालो दिवपाक बांदील आसा विधिक्त सेवा प्राधिकरण नालसा न्याय सगळ्यां खातीर
We are deeply honored to have with us today Honorable Srimati Justice Bharti Dangre, Senior Judge, High Court of Bombay at Goa, Honorable Shri Justice Valmiki Menezes, Judge, High Court of Bombay at Goa, and Chairperson, High Court Legal Services Committee. Honorable Shri Justice Ashish S. Chavan, Judge, High Court of Bombay at Goa, Honorable Shri Justice Shriram V. Sirsat, Judge, High Court of Bombay at Goa, Senior Advocate Shri J. E. Koel Pereira, President, Goa High Court Bar Association. Your gracious presence lends great significance to this occasion and inspires all of us to strengthen our understanding of forensic evidence in the practice of law. We are delighted to present you all with potted plants, a token of our appreciation for your presence and support. Requesting Member Secretary Ms. Shabnam Sheikh to kindly present the potted plant to Justice Bharti Dangre. Calling upon Advocate Shivan Desai to present Justice Valmiki with the potted plant. Advocate Rama Rivankar kindly facilitate Justice Ashish S. Chavan. Advocate Saili Kenny, please present Justice Shriram Sirsat with the potted plant. And lastly, Ms. Maria Correra, Advocate, kindly present Senior Advocate Koel Pereira with the potted plant. Without further ado, let us commence, and I now invite Honorable Shri Justice Valmiki Menezes to give the introductory speech.
My colleagues on stage and all the participants that have gathered here. I believe many of the participants are either watching on the YouTube channel or joined in on the Zoom platform which we have provided. Today's seminar is a series of 3 seminars in a workshop. Let me tell you the background, by which this set of 3 seminars, and we hope to have a lot more, evolved. In the past year or so, we've been coming across a lot of cases, matters that come up for bail. There are some matters that come up from the trial court, where we have realized that where eyewitness evidence is not there, the entire case depends on circumstantial evidence. The forensic evidence collected and the scientific approach to investigation plays a huge role. We also found that both on the side of the lawyers, the prosecutors, and on the judges, as well as the investigators, while examining matters, that this is not to be critical about the system, but we found that we are not educated enough, perhaps, in understanding the whole process of collection of scientific evidence, collection of forensic evidence, the approaches to forensic evidence, and the evolution of the whole science of collection of forensic evidence. You must have noticed that in the past few years, there are various changes in trends in how forensic evidence is viewed by courts. So obviously, the investigation has to fall in line with what happens in courts and the views taken by courts. There's often a great mismatch. There's also an issue about how to present a lot of this forensic evidence and how this is to be proved. So, what better way than to actually come up with programs where we can all, that is, the judges, investigators, the forensic scientists, prosecutors, and lawyers, all gather under at one forum and discuss these issues. We did call in at that time, this was about 6 months ago, we did request the director of forensic laboratory here in Goa, Mr. Ashutosh Apte is present here today, to give his views on the matter. And he, of course, threw the doors open of the forensic laboratories to allow our judges. I understand most of the judges by now has visited the laboratory and understood the processes of analysis of the forensic evidence that comes to the lab. But we thought we'd still, have a seminar where right from the stage of the scene of crime to the stage of the final judgment in the matter, the whole process of collection of forensic evidence, analysis, presentation in court, and then the judgment should be discussed under one forum. This was the whole basis on which we evolved these workshops. So this was the background, and here we are today. I must take this opportunity to acknowledge the help, of course, of various players in putting this whole workshop together, starting with the director of the Forensic Sciences Laboratory, Mr. Apte, the police department. The Inspector General of Police has been very kind to make sure that some of the investigating officers at the PI level, we requested them to be present also today. They'll either be watching it on the YouTube channel or participating in the interactive session through the Zoom platform. The prosecution department, thanks to the director of prosecution, I see a large number of prosecutors here and many have joined in. Thanks to the district judges, both the North and South PDJs, who ensured a large participation of the judges over here. And of course, the various bar associations, they have, not only the lawyers are present, but I know that they are online. A large number of lawyers are online watching this program, and we hope they interact. Besides this, I'd like to thank our own member secretary and her entire team. It's not easy to put together a program of this sort. And the team from the High Court that has helped out with creating the Zoom links and creating the and putting the entire program on the YouTube platform so that it's viewed. Ultimately, the idea is that this is a legal education and legal awareness program. It must be watched by the public for them to understand that we do deliberate and discuss these issues to see that the entire legal system is vibrant, and dispensation of justice is just doesn't remain static, but it is as evolutionary as the area of scientific collection of forensic evidence and scientific approach to forensic evidence. So please participate not just in this program. My request is there are 2 more programs to follow, and we are trying to put together a series of more relevant issues that we can all discuss in the time to come in the next year as well. So thanks for coming and participating. Thank you very much.
Thank you, sir. And now, to formally mark the beginning of the 3-day workshop, I call upon Srimati Justice Bharti Dangre to deliver the inaugural address.
my esteemed brothers, Justice Valmiki Menezes, Justice Ashish Chauhan, Justice Shriram Sirsat, the President and the Secretary of the Bar Associations, the respected senior counsels who are present here, and all my dear friends, including the judicial officers who are present, the prosecutors, and also those who are watching this program and participating in it online. As we all know that as far as the criminal process is concerned, when we talk of a trial, the success of a trial is not dependent upon the quantity of evidence, but it depends upon the quality of evidence that is led before the court. The prosecutor, the public prosecutors, as well as the judge, the trial judge, is confronted with so many situations. And that is the stage when the evidence is led before the court, and then it is appreciated to result into a judgment. Of course, when the matter comes to the High Court, or when even it goes to a higher court, to the Supreme Court, there can be no change in the evidence. The evidence remains the same. So you can understand how much significance the evidence has in a process by which a person is converted from a suspect to an accused and from an accused to a convict. With a simple reminder that there is not going to be a single change in the evidence. What the complainant has said here in the court is going to continue no matter the matter goes to the Supreme Court. With the enactment of the Information Technology Act in 2000, many changes were brought in the IPC as well as the Evidence Act. Now see, it's almost 25 years that this act is brought into force. But still we are struggling how to appreciate the electronic evidence. For a long period of time, with the Evidence Act being in force, we were struggling with what is primary evidence, what is secondary evidence. By the time we could barely settle it, the new act came. A new forum opened as to what would be amounting to electronic evidence, because this was not something which we ever, in 1872, the Evidence Act never contemplated that evidence can be, at that time what was expected was there will be only an ocular evidence or at the most documentary evidence. Now to conceive that evidence in form of an electronic record, how do we construe it as a document? For a long period of time, we all know, and of course we'll be discussing the theoretical aspect of it, because there was a lot of jugglery between after the decision came first in case of Navjot Singh Sidhu, because when 65B was introduced in the Evidence Act, as to how would you prove or what should be the proof of the electronic evidence, it contemplated a certificate given by a person who is in charge of the device. Now it can be a hard disk, and if it is a hard disk, or if it is operated regularly, then to be shown, to be established that this is the device which was in operation. The evidence came to be, or the recording was going on in normal course, and it is not tampered. Because as we are quite conscious of the fact that when you bring a document, there is every possibility that a document may be a tampered one. It may be forged document. The signature may be forged. When it comes to a will, you have to prove that this is the signature. The witnesses will come into the witness box that this has been executed, or any document having been executed, being registered. Because the instances are not rare when somebody else's person stands without identity. Now, when it comes to electronic evidence, it's not that it will also have to meet the threshold of the scrutiny. It can't be like that you simply tender an evidence, it is going to be accepted. So you will have to exclude the possibility of it being tampered. So when you are relying upon electronic evidence, the thing is its genuineness. You will have to test it. Now, who will give an evidence? Therefore, the provision was introduced in 65B in form of clause 4, saying that a person who maintains that device will give the certificate that it was getting recorded in normal course of time. It was not shut. It was all the while in operation. Now, right from we all know the famous Parliament case, Navjot Singh Sidhu's case. Thereafter, there was change. It said that the decision was overruled. Then came another view in case of Shafi Ahmed. And ultimately, what is holding the field is now the decision in case of Arjun Khodpal. Now, see, it's very easy to produce when you produce the device itself in the court. I mean, you have recorded something in the mobile phone, and if that device itself is produced in the court, then you don't require 65B certificate. But when you transfer the data from that mobile device into some other mode, you take it on a chip, or you record it and you record it on a pen drive, and then you bring it before the court, then this transfer of data requires a 65B certificate. Now, to large extent, the position of law is cleared by Arjun Khodpal, that it's not that when you produce the device, it's not mandatory that you have a 65B certificate. There was also a conundrum about who will issue the certificate. Now, at times, I don't know, I mean, when we deal with this WhatsApp chats in many of the matters, specifically POXO cases, 376 cases, now that every time, or rather for that matter, if you come across a matrimonial matter, you'll find that as if the whole thing was stored. I always wonder as to from the first date of marriage whether the couple starts recording everything. So you find everything, you have a heap of documents annex that this is the WhatsApp chat, or a couple is in relationship, not necessarily a matrimonial relationship, and you find that right from the day you say hi, hello, then love, then what, hatred, then everything is there. So you have a heap of document. Now, the police, what they do is they seize the mobile phone, send it for forensic analysis. I have never seen in any case that the analysis has actually been brought on record, because till that time something happens and the conviction or acquittal takes place. But the question is this: who will issue? And if it is not there, if the data is transferred, because all we know that now it is all stored in the iCloud, then when I research something, I realize that, because normally what is your habit in the morning? At least I am in a habit of deleting every day. What you do is delete the messages which are unwarranted. So you can't imagine that storing those messages for 2 to 3 years. Then you realize that these messages are stored all in the iCloud, and you can really have a download of it at the time when you want. So that's how. But the question is this: if it is not in the device, how do you deal with this evidence? So there are peculiar circumstances which we come across, and we always want answers from the experts. Fortunately, today we have 2 experts who are talking on this electronic evidence, as a part of it that is electronic forensic evidence. We are not going on general forensic. And the other is cybercrime. Now, cybercrime also, probably every one of you must have watched that series known as Jamtara. Now, it was amazing. You can't believe that young people indulging into all such type of activities, and so difficult to capture them. I mean, amongst all those, you see cyberbullying. I hope all of you have read the book which says the dark net. And then you realize that there's something more deeper into it. It's what we are looking at is not even 5% what the author says. There is so much of trading, there is so much of sale of narcotic drugs, which is all taking through darknet. Now, with this new technology, the crimes are on the rise, cases are on the rise, and as I always feel that when we think that the police machinery or we judges are becoming smart, the criminals are getting more smarter, because they know how to evade this. And we are confronted with, when we take the statistics, you'll find that not even 5% of these cyber crimes are really detected and the convicts are punished. We would like to analyze what are the reasons. Are the investigating agencies lacking somewhere? Or are the courts are lacking somewhere in appreciating the evidence that is placed before it? So if we want to really understand, because this is very important for the prosecutors, even for the lawyer, for the accused, the trial court judges, and even we as high court judges, because this is a field which still after 25 years is, we can say, full of nuances for us. We don't know how it is really appreciated. We can deal with the legal aspect of it, but what's the practical aspect is also equally important as to how it is going to be traced, how the electronic evidence will have to be appreciated. So this seminar, which is divided into 3 divisions, and I must congratulate my brother Justice Valmiki on behalf of the Goa State, who on behalf of the Goa State Legal Services Authority has arranged he thought of such an idea that having a seminar not exactly on one day, because then it becomes too much of bombarding if you have lectures after lectures. So it's a very nice idea to have it spread into 3 parts, to be followed by an interactive session. And we may discuss it because we are lawyers, we are judges, and what are we going to discuss ultimately is only what is the law that has been laid down. But with the experts which we have today, we are going to get an insight into the practical aspect of it, which according to me is very important. And I'm sure that the end of this seminar, after all the three sessions, provided all the three sessions are attended by all of you, definitely you are going to have a take home which is going to help you in whatever role you are playing, either a prosecutor or as a judge, as a trial court judge, or even for us who are appreciating the evidence let down before the trial court when the matters come in appeal. Thank you very much for inviting me. And I must say that the Goa Legal Services Authority has done a commendable job. Firstly, for the reason that instead of having some, what you can say, legal aid camps and all, this is a sort of legal aid because we are being provided the legal knowledge by through the Legal Services Authority. And I wish this program a great success. And I hope and trust that each one of you will have some takeaway from this session today. Thank you very much.
Thank you, ma'am. We now request our distinguished guests to please take their seats among the audience as we are about to begin the much anticipated presentations. Through expert presentations and an interactive session thereafter, we look forward to productive discussions and practical learning. While the technical team makes the necessary arrangements, let me introduce presenter number one. Presenter number one is Mr. Rahul Gupta, 2017 batch IPS officer of AGMUT cadre. He is presently posted as SP North, Crime and Cybercrime in Goa. He holds B.Tech, Electronics and Communication, and M.Tech, ICT degrees from IIT Delhi. He has served in Delhi, Arunachal Pradesh in the past. He has been awarded with Kendriya Griha Mantri Dakshata Padak, Katin Seva Padak, and Antrik Suraksha Padak, and DGP Commendation Disc during his service period. Mr. Gupta, the floor is yours.
Good evening. Thank you so much for this opportunity. All the respected honorable judges and my colleagues from the other side of criminal justice system, all the defense lawyers, and as well as all the neutral balancing actors, public prosecutor, and all the police officers who have joined online, and public prosecutors and other judges who are with us online in this session. I thank I thank the Legal Services Authority for this opportunity. We had discussion that we will have a cyber forensic session, but then I convinced Mr. Valmiki sir that I would like to shed some light on the latest trends of cybercrime, so that everybody knows, and anybody can be victim of cybercrime. I have seen that CEOs of multi-million companies becoming a victim of cybercrime, IAS officers, IPS officers, bank officers, they are victim of cybercrime. So before entering into digital forensics, I would just touch upon cybercrime, latest modus operandis, and how do we deal with such cybercrimes, and then this digital forensic part will come. The practical aspect I will emphasize upon, and the last thing will be one legal aspect regarding the how do we release the money of victims that is frozen into the bank accounts of fraudsters. how do we get that money back to the victim? There are some legal lacunas there, and we had some discussion with the public prosecutors, our DOP madam, and also Aga sir also as well in past. But there is a deadlock which is still prevails in this aspect. So I would like to touch upon that aspect also, so that we have some clarity going ahead. I'll start my presentation. Cybercrime, as we all know, that it is use of communication device. It can be a network, it can be a digital network, it can be computer, mobile, to commit any kind of crime. That crime includes generally a financial fraud, social media based fraud, or identity theft, data breaches. All these qualify as cybercrime. One interesting aspect is that the crimes which are happening right now, there are also elements of cybercrime in normal kind of crime also. So if we see that a lot of in a lot of cases, there are many conspirators to any kind of bodily offenses also, and they generally interact on WhatsApp or FaceTime. They have their own WhatsApp groups in which they plan everything. Then they also do group chats, group video calling. So all these things happen, and they ultimately cybercrime is starting to touch each kind of crime, and this is why the forensics part of cybercrime is important for any kind of lawyer, not just the lawyers who do the IT Act cases. Key elements of cybercrimes are negligence, greed, and fear. This is what makes any person victim of cybercrime. I would touch upon how these elements of human, these vices of human that lead them to become victim of cybercrime. It can be targeted at individuals, property, organizations. It is governed by IT Act, IPC provisions. I would just like to highlight the extent of problem in India. This is the number of cyber complaints which are received every year. In 2020, 10 lakh complaints were received. In 2023, 16 lakh complaints were received. These are just complaints. These are not FIRs. These are complaints which are reported on some National Cybercrime Reporting Portal or 1930 that we have. And 2024, you can see it almost touched 23 lakhs. So this is the amount, this is the number of incidents, number of complaints which are received everywhere. If you look at the quantum of fraud, that how much money that was siphoned off in these kind of cyber frauds, in 2024 it was 22,000 crores. In 2023 it was 7,465 crores. So we can see that there's a almost it has become thrice compared to 2023, just 1 year. And this year's figure we are still calculating, and it should be, because now the awareness has increased a lot. We should be up to 2024 level. This is what all the state policies and central government is targeting. So I would just say that cybercrime involves not just social media based crimes in which we have fake profiles, impersonation, cyber stalking, cyber bullying. There are financial aspect to it that, as ma'am also mentioned, that Jamtara is a famous example that everybody knows, that they call some victim and they, one or the other pretext, they tell them to transfer some amount in the name of the credit card renewal or maybe insurance claim. Or maybe I myself received a call about Mediclaim. My Mediclaim is pending. I said I don't even have a policy. How would I? So they try to like randomly try, and sometimes when some of them disconnect their number, they call to me when they realize that I am Rahul Gupta, and they some of them said my name, because since now the influence is increasing. Extended problem. This is the number of complaints. 2024, we had 2,032 complaints. In 2025, this number is 147. That is up to 10th of September. 10th September 2025, we have 1947 complaints. So we might overshoot last year's figure this year. These are complaints. Again, these are not FIRs. These are complaints. So one can appreciate that if we start converting each and every complaint to FIR, that will clog our system. Not just police, but also judiciary. Everybody will have to dispose these cases. So it will take time. So it is practically not possible to convert each and every complaint into FIR. But there's a, what should I say, light at the end of the tunnel. Even the number of complaints have increased, but the number of the amount of fraud, the amount of money which is going out of Goa, it has reduced. Till 10th of September, we can see that 49 crores have been siphoned off. Last year, for whole year, it was 101 crores. Till date, last year, it was around 57, 58 crores. So we should uh, reduce this year's quantum of fraud. And last, the percentage part is the amount that we are able to block. The financial fraud, when it happens, money travels through a network of mule accounts. There are many mule account agents sitting across the country who have in their possession hundreds of bank accounts, hundreds of SIM cards, and they get a signal from cyber fraudster that so much of money is coming to your account, and you withdraw it at within 5-10 minutes. So they have their agents at respective bank branches with pre-filled forms to withdraw the money. They have agents who are lined up at the ATM machines, and as soon as they receive the signal, they withdraw the money or they transfer the money to other bank account. So this is how the network of mule account is facilitating the flow of the money out of the country, because they have to, if they keep it in one account, then it will be reported very soon. So they have to layer it into multiple accounts. We have seen that in a typical cyber fraud of 50 lakhs, generally the bank accounts which are 50. So this is the amount of investigation that we have to do. So we can have at least 50 accused in one cyber case. So this is, and those are scattered across the country, not just in Goa. So if any of the judges might be able to recollect, in most of the cyber cases, the accused that we are bringing for the production are outside the state. Hardly anybody is from Goa, because we generally try to target the person who is the maximum culpability, and that is generally a layer 1 account holder. The person whose bank account was given to victim to transfer the victim's money to the fraudster account. That is a direct involvement. So we have a portal at the back end that identifies the layers in which the money is flowing. Layer 1, we have 10 accounts. Layer 2, we have 20 accounts. Layer 3, we have 40 accounts. Something like that. So layer 1 is the maximum culpability kind of accused. So that is what we target generally. This bank account, this flow of the money, more 16% is the blocking percentage, and it is increasing every day. Modus operandis are fear-based, digital arrest, cyber extortion, digital arrest. How many of you know digital arrest? I'm not, judges might be knowing. I don't know about lawyers, because most of the judges must have encountered a case by now. My lawyer friends, advocate friends, no, nobody is okay. So, are you sure? Nobody knows about digital arrest. Okay, I will explain in subsequent slides. Then greed-based frauds are there. Trust-based frauds are there. Trust and ignorance is the same thing. That if you trust somebody, you ignore their fallacies. I will explain each of them in subsequent slides. So this is the data. I will not spend much time. That how much money in each head. So digital arrest scam. Scammers impersonate as law enforcement official. They accuse victims of crimes like money laundering, and they demand payment on video call. So you might receive a call that I am from FedEx, and you had sent a parcel. You had sent a parcel through courier, and there was some drug detected in your parcel, and that is why I have to transfer your call to Mumbai crime branch or Delhi crime branch. So this was the starting of digital arrest scam. Now they have changed their modes, and they sometimes say that your account is involved in money laundering case. There was a Jet Airways scam in which Mr. Naresh Goyal was arrested. They say that your account is linked to that case, and the money has been laundered through your account also. If somebody is a high net worth individual individual and he has transactions outside the country also, he might fall into this trap that I keep on transferring to him. Then it might be a possibility. That's how they create fear inside you that, okay, my account might be involved. And then they will say that your SIM card, there are some suspicious activities which has been found from your SIM card. So it is possible. Anybody would say, okay, it might be a possibility. Okay, let me speak to Mumbai Crime Branch. And then this scam start that they will do a video call pretending to be a police official, and then they will say that uh, if you have to get yourself safe, you have to transfer so and so amount of money. First they frighten you, extract some money from you. So there are today only there was one scam, 1 crore of digital arrest reported today itself. This is just an example which I have written. So this is how they call this. They do video call and they can have picture of actual police officer, and then they are at the other side of the video call. They will mimic a setup like a video like a police station. There will be a police officer sitting of inspector rank. There will be some orderly who will come. He will say, "Jain sir, may I serve you something?" So they make this victim believe that he is into some genuine kind of trap. By the way, this picture is of my friend who is posted in UP, is SP Bagpat, and they have used his picture to this in this fraud. So they produce all kinds of document that CBI. It has Aadhaar number also of the victim. So it means to say that there is some leakage of data, that they have name and Aadhaar number of victims that they're targeting and the mobile number also. They give these kind of documents to them. So the forgery section is also attracted. Investment scam is increasing now. A lot of investment apps are coming and the victims don't know what is genuine, what is not. And out of their greed, they in the hope of high returns, they invest their money, and ultimately that platform is fake. And when it will show you that your investment is increasing, you will get a very good return. But when you actually ask for return, they will not give you return. They will ask for some fee. They will ask you to make more investment, and that is how a person gets trapped. So BlackRock clone example I have given. So the best way is that in any investment platform that we are investing, we should have this savvy website from which you have to verify whether it is genuine or not. Task-based fraud. Now, since these are the top 3 kinds of fraud, task-based fraud is again greed-based fraud. Victims are asked to perform online tasks with the promises of profit, and they are cheated then. So you might be seeing some messages that घर बैठे 500 रुपए कमाइए, घर बैठे 200 रुपए कमाइए, 5 मिनट का काम 200 रुपए, वो इस तरीके से होता है टास्क बेस्ड फ्रॉड. So उसमें they will ask you to perform some Google reviews, they will ask you to give some feedback on a survey, and they will give you 200, 500, 1000 rupees, and the tasks will get complicated, and the money that you will have to, they will even ask you for advance money to participate into the task. That's how they get money from you. And sometimes this task based fraud converts into investment scam. They tell you that you will have to invest, you can, to get a very good return, you should buy shares of this company, and we have a platform through which you can buy shares. So this is how it is happening. Fake loan, there are many fake loan apps available. Government from time to time takes them down, but they are still flourishing. And these apps offer instant loans, but they steal data. They take all the permission from the device and they steal the data, and then they harass the victim. So I used to receive calls when I was in my previous posting in Arunachal Pradesh, that one of my constable had taken some loan from such kind of fraud app, and the fraudster used to claim that, sir, you are the guarantor of this person and you have to give me money. Guess the amount of loan that was taken, 1,000 rupees loan, and they were telling me that, sir, you have to give me 1,000 rupees back. So ultimately what they had is that they had access to his contact list, and they used to call everybody, somebody give them the money. So phishing is a cyber attack where victim impersonate legitimate institutions. We have SBI emails. Sometimes we receive for some refund request. Income tax refunds also, it had happened in past. Then there is this electricity bill, sometimes through which we have to pay the bill. So this is how phishing attack happens when a platform, genuine platform, is being impersonated by a cyber fraudster through one or the other way. And this includes all this website, hotels, websites of hotel and resorts. It is very common that there are many hotels and resorts which have their one authentic website, and then they are listed on all the internet platform like Make My Trip and Trivago, and all these platforms are there. But let's say if I get a deal of 7,000 rupees Marriott, I might feel that I can get a better deal if I search online. So if I search online, I might encounter many fraudulent website also, and then they will take the money from me at the end. So that is also kind of phishing scam. DDoS is a scam when a lot of requests come. Let's say I code website on which citizens interact for one of the services, but suddenly through some algorithm, a lot of requests start coming simultaneously, and the system is not able to deliver. It is actually blocked for genuine person because of this fraud kind of request. A lot of requests are coming from, let's say, China or Pakistan. So the person who actually needs services from MyCode website is not able to access. That is called denial of service attack. Aims where the data was hacked by some ransomware, and they had asked for a lot of money, that too in cryptocurrency. Sextortion, scammers lure victims into video calls, secretly record compromising apps and extort money. A lot of times we see victims out of their loneliness, they befriend somebody online on Facebook, and then they ultimately share their photos in compromising position, and that is how the fraudster blackmail the victim. Cyberbullying, repeated aggressive online behavior intended to harm individuals. It is very common, especially in school or youngsters. They are generally at that age they are targeting each other. Cyber stalking, generally females becoming victim of cyber stalking. Fake website, I've already told. Fake password. It includes this government website as well. Fake passport website. They are there online. We try to take them down generally. So as cybercrime department has power to take down the website if it is found to be involved in illegal activities. So if let's say we have an FIR registered against a website, we can write to the all internet service providers and all the internet web hosting services. We can write to them and they have to block the website. So that is the 73B of IT Act, Information Technology Act. OTP fraud, scammer tricks user into revealing OTP sent to their phone. That is a typical Jamtara kind of fraud. That they will say that by mistake I had transferred some money to. Can you and through some social media share the OTP. And the RBI guideline says that if the amount is, let's say the victim did not by his fault or her fault share the OTP, and if the amount is less than 1 lakh, then banks have to refund that money back to the victim. So let's say there's a cyber fraud of less than 1 lakh rupees, and you tell your bank that I did not share the OTP. Somehow, or I did not make transaction out of my own will. Bank has to refund that money back. Online job frauds, a lot of, so how these cyber frauds are happening? Because employment seeking youth, they cyber fraudsters to join them in call centers that are flourishing outside the country. Thailand, Myanmar, Cambodia. There is this cyber call center in which thousands of Indians in Pakistan are sitting, and they are through this online job fraud, they are lured and they are taken to these call centers, and from there they are committing all these cyber frauds. So, these are of sophisticated frauds offering fictitious job opportunities to job seeker. This type of fraud are normally done through online services such as bogus websites or through unsolicited email claiming to be from known companies. It has become difficult. Job offer is legitimate of fake. So they will promise that it's a this hotel in which you have to come for a housekeeping job or a receptionist job, but ultimately it is a call center kind of job. So they should the victim should verify the website on LinkedIn whether it is genuine or not. General cyber safety precautions: do not share OTPs, pins, password, verify links, use strong passwords, update antivirus software, don't respond to unsolicited calls, emails, use parental control tools, supervise children's internet use. This is very important because a lot of children of our colleagues, they might be using their mobile phones to play a lot of games. And through these games also a lot of cyber frauds are happening. So one should have parental control on the smartphone which is being given to the child, and they should definitely monitor the activity, what kinds of game they are playing, and what kind of access to data these games have. A game should only have access to microphone, probably speaker, maybe gallery, but not gallery is also not that important. So it depends on game. But you should see that what this game actually does and what kind of permissions have been given to this game. Report the suspicious activity to cybercrime.gov.in or 1930. So these both are the national helpline and portal on which cyber fraud can be reported. So now we come to digital forensics. So if we go to any kind of scene of crime, or let's say even we do not go to the scene of crime and we conduct investigation sitting in our office, what kind of digital evidences that we encounter? First is personal and computing devices, computer and laptop, hard drive, SSDs, external drives. There are a lot of documents, images, browsing history, user account, deleted files. All these things are of our interest. We had a case in which one fake document was created of an agreement with companies, and the signatures were forged. And that accused revealed that he had made that document on this computer. So we seized the entire CPU. And, we sent this hard disk to FSL. I will explain what exactly was done. Mobile devices, smartphones, tablets, cell phones, call logs. Mobile devices are seized in every case, not just cyber case. In every case, we seize mobile devices. And there are sometimes cases where data is deleted, but through forensic experts, sometimes we are able to get that data also. GPS data, app uses, photo. Call logs are very important. Not just normal call logs we can get from CDR also. But WhatsApp call logs, FaceTime call logs, those are very important. Digital cameras, photos, videos, associated metadata, timestamp and geolocation. That is very important, that it is actually connected to the scene of crime or some case. So that data is important. USB drive storage that contains documents, spreadsheets, and various files. Gaming consoles. In rare cases, we get these gaming consoles, user profiles, message histories, saved game data. Network services, cloud services, we have files, emails, documents, backups stored in platforms like Google Drive, iCloud, Dropbox. Man had spoken about WhatsApp chat being uploaded on iCloud. How do we make that an evidence? So whoever is using iCloud, we have to, through disclosure, we'll have to download that copy of iCloud under 27 of Evidence Act. So I'll just clarify here itself. When we do such cases, we have sometimes we have to see something from Facebook, from his Facebook profile. So what we do is we take this 27 Evidence Act, in which recovery is done on the disclosure of the accused. We ask accused that where is this photograph of your with another accused? He says that I had uploaded it on Facebook. Then we ask him to log in to Facebook by his own free will. He logs into Facebook, and then he downloads that the copy of his whole file. You can download Facebook data. There's this option on Facebook that you can download that data. And he in that Panchnama he writes that I writes that I interrogated the accused. He showed me his Facebook profile. He logged into his Facebook profile by using this username and password. Then he pointed me towards the Facebook data, which was of my interest. Then he downloaded this Facebook data and he stored it in his pen drive. Whose hash value is this? So this is how this kind of iCloud or WhatsApp chat or whatever we have to take from user. That is what we do. 27 Evidence Act. It's not just for weapon reference. It's not just for crimes. It can be used for Facebook profile, Instagram profile, or any kind of iCloud data. But the problem is a lot of our users are not following. We are trying to educate them. So social media again, I've told that how do we extract all these things. Online accounts, email records, browser history, user activity, Internet of Things, data from smartphone devices, fitness trackers, network and server logs. That is very important. A lot of in cases we have seen that accused is using the Wi-Fi of a hotel. So if we take the IP address, it becomes a static IP of that hotel. But how do we trace the accused from that static IP? So we'll have to get the IP logs of the internet service which is operational in that hotel, and they will tell us in this timestamp which of the actual IPs are logged into this private IPs are logged into this hotel network. So that IP log we can get from the network administrator of that hotel along with 65B certificate, and that will be admissible evidence under this Bharatiya Sakshya Adhiniyam. Surveillance system, CCTV footage, dash cam footage. Again, now it depends CCTV, how we're taking CCTV footage. If we are seizing evidence, it's a primary evidence. If we are making a copy of it by extracting a footage of our relevance of let's say 5 p.m. to 6 p.m., then we have to get 65B certificate from the person who operates that CCTV. He will identify the data that is being given to us, the type of device that is there, and he will say that I am the person who uses this, operates this device in course. And that is what gives some idea that CCTV footage part will become admissible. Otherwise, that's a shortcut that you seize whole media and you produce it as primary evidence. Databases and financial systems, transaction data, customer records, employee information. So we ask for all these information through emails. We tell them, we ask for that, what is the account statement of this particular bank account of last 6 months. But then we have to produce it in the court. So we'll have to take 65B certificate from the bank official, or maybe when we take CDR also secondary evidence. When the notice officer give us the 65B certificate, then it becomes admissible. So generally, the tendency that I've seen in Goa is that generally they don't take 65B certificate in CDR. Because it takes some times and it takes significant time. So we don't want to breach that 60 days and 90 days limit. So generally we do CDR record, then we generally use it as for investigation, for identification of the accused, not as a case file, not as part of case file. That is the general tendency. We rely on other evidences to prove the case. Transaction data, customer records, employee information, printer logs of printing document if the documents were printed, voicemail, audio recording, stored audio message, digital voice recording, depends on case to case. So any kind of scene of crime, when we visit, we identify what are the sources of information. Then we isolate that scene of crime by using tape and everything, by controlling the access, and then we start documenting that what I am seeing in this scene of crime. That is sort of panchnama. That I entered into this scene of crime. I saw 5 computers which are plugged into 2 of them. Sources, their make and model was so and so. I recorded their this. There was some barcode on which identification number of each and every computer was there. I recorded that also. Then I disconnected the power source, and then I took a RAM dump. Then I took hash value, and now I am producing it. Producing this to producing a copy of this this RAM to the FSL. I'll explain this process. So this documentation, it takes a lot of time. In this documentation, we have to label each and every evidence. Generally, this is the similar process that is followed in normal scene of crime. Like we have blood stains, we have clothes, we have other kinds of DNA markers, we have shattered glasses. Similarly, we have USB, we have hard drives, we have computers, we have Wi-Fi routers, each and everything. Cable, battery packs, software drivers, all of these things are also identified. Then we forward to FSL for accuracy analysis. How do we do it? We have to maintain chain of custody. So we have to use write broker to make a image of this particular file, whatever file we are extracting. And through the use of a write broker, we can calculate hash value also. The write broker are coming in different varieties. Some of them not just block this tampering, but they also provide hash value. So at that moment, you can record the hash value, and then you write it in the panchnama. And later when you go to the lab, you can make a copy of that this particular device that you are seizing, and that copy can be kept for your own investigation. And the original device that you have seized, that has to be sent to FSL along with the forwarding note. What kind of questions we want FSL to examine. All these questions are wrote down on that forwarding note, and then FSL at their end also and they examine the evidence which was given to them. So generally, it's up to us how much careful we are and how much we are interested in each and every device. Sometimes we each and every device, only the devices which are of our own, which are of our interest. Those devices only copies taken. Safe storage is done in each case. So step 2, I would like to shed some light how to isolate. When the computer is on and locked, we should take the RAM dump. There are many softwares which are called Win Audit. There are many similar software through which we can take the RAM dump, and then we seize then we switch off the power supply, and then we use a write blocker and forensic imaging to send it to FSL. Calculate the hash value. Many are there, SHA and MD5. Enter the hash value season. Get the 65 certificate. Whoever is operating the write blocker, we have to take 65 certificate, and then photograph activities are done on this scene of crime. So this is when the computer is on and unlocked. When the computer is on and locked, we have to select switch the computer in hibernation mode. And then when it is analyzed, it is then taken to lab, and it's analyzed, we can get the content, timestamp of the when it was switched off, it was hibernated, and the status of the files, because chain of custody, we have to that this was the state in which that computer was seized. So all these details we can get from this file, hiber.sys, page file.sys. It's very technical kind of terms, and these contain all information about the device. When the computer itself, I should not turn the system. Challenge is to do the system time, remove the storage system into BIOS mode. BIOS mode is the date and timestamp note down this information, photograph, and make entry in the Panchnama. This is how the process is done. All these things we have to note down that all the barcodes information so that we can identify the evidence, because ultimately the defense lawyer will come and say that this was not the computer that you extracted, there was some other computer. So we have to exactly pinpoint. We have to label each and everything. Wires we have to label, and then we have to release the wire. There was some, yeah. Unique identifiers are must. These are devices which are used. Forensic duplicator that can create a copy. Hard disk cloning devices are separately. There is write broker. So when you connect a hard drive, so this is a hard drive. This one is in the third image. There's a hard drive at the top right upper side, and then it is connected to write broker, which has green and red light, and then it is connected to computer. So the battery is changed. And in the computer, we have imaging software which will extract everything. Caesar memo, all these things this is the modern Caesar memo. It is not, this is like, you have to include everything, but it depends on state to state. We have circulated this kind of memos to everyone, but there's slight variation everywhere. So it includes everything, make, model, what is the, when the photograph was taken, name of the Caesar officer, whether the RAM dump was collected, forensic tool used for that, if system was off, what was done, what was the hash value, all these things are there. This is the digital scene of crime kit. Hard drives we use to isolate the system, hard disk and computer. We use bubble wrap so that there is no accumulation of electromagnetic charges that can temper data slightly. So that's why this bubble wrap, anti-static bag. Faraday bag is used to prevent the mobiles to connect from any kind of network. So we have all these equipments with us, and they are part of the IO's kit. They are taken to scene of crime. This is an example. This is how hard disks ideally should be packed.
जाना चाहिए। साइबर क्राइम के केस में पुलिस छापे के दौरान यदि कोई व्यक्ति कंप्यूटर पर काम कर रहा हो तो उसे तुरंत वहां से हटा दें। कंप्यूटर को स्विच ऑफ नहीं करें, केवल बिजली की सप्लाई को हटा दें। हर प्रकार की टेलीफोन लाइन, इंटरनेट केबल को भी तुरंत हटा दें। इस बात का ध्यान रखें कि कंप्यूटर को कब्जे में लेने के बाद दोबारा न चलाएं। फ्लॉपी, सीडी, डीवीडी, पेन ड्राइव आदि जो भी स्टोरेज मीडिया उपलब्ध हो सभी को कब्जे में ले लें। प्रयोगशाला में भेजने के लिए अगर संभव हो तो हार्ड डिस्क निकाल कर भेजें, अन्यथा पूर्ण सीपीयू को ही प्रयोगशाला में भेजना चाहिए। लैपटॉप में से हार्ड डिस्क निकालने की कोशिश ना करें, वह पूर्ण लैपटॉप को ही प्रयोगशाला में भेजें। हार्ड डिस्क को प्लास्टिक की पैकिंग में या थर्मोकोल की पैकिंग में भेजना चाहिए। हार्ड डिस्क को आंच, पानी, झटकों इत्यादि से बचा कर रखना चाहिए।
So this is how scene of crime visits generally take place, and this is the Caesar that we do. So this is the physical scene of crime of cybercrime cases. We have seized a lot of, in a lot of cases, we have seized Wi-Fi routers, computers, pen drives, and in all these cases, this process is almost followed. Sometimes IOs have some lapses, and that is what defense lawyers take advantage of. So now Bharatiya Sakshi Adhikar has made it very clear that electronic records, electronic or digital records are also part of document. And this comes under a section 2 of Bharatiya Sakshi Adhikar. And electronic record on email server, books, documents on computer or smartphone, message, website, locational evidence, voice messages, all these are documents. Whatever is stored in digital devices, that is a document. From IT Act, some things we have to derive from IT Act. Now they've included everything here. All our colleagues must be the difference between primary and secondary evidence, and that 63 of Bharatiya Sakshya Adhikam that dives deep into how secondary evidence has to be presented, into how it becomes admissible. So part 4 is of most importance, that manner of producing the electronic record and responsible official position. That has to be given along with the evidence. Secondary evidence is produced. This is in detail identifying the electronic record containing the statement. Part A is of the 63 part 4, identifying the electronic record containing the statement and describing the manner in which it is being produced. क्या वो इलेक्ट्रॉनिक रिकॉर्ड क्या है जिसको मैं प्रोड्यूस कर रहा हूँ, एंड उसको कैसे प्रोड्यूस कर रहा हूँ, गिविंग सच पर्टिकुलर डिवाइस, जो डिवाइस उसका क्या पर्टिकुलर है, उसका हैश वैल्यू वगैरह क्या है, उसका मेक मॉडल क्या है. दैट इज व्हाट कम्स अंडर पार्ट 2, दिस सबसेक्शन बी. एंड पर्सन इन चार्ज, उसका डिटेल, दैट इज ऑल्सो वेरी इंपॉर्टेंट. So this is what comes under 63(4). There is some legal there is a ambiguity that at the end and experts shall be evidence of any matter stated in the certificate. So now it contains two parts. Given by the person, and then the part 2 has to be given by the expert. So that still has not yet come in any of our case. A lot of states are also grappling with this, that who this expert is going to be. And I'm sure that some clarity will come in due course. We are still deliberating at our level about what is to be done of this expert. Ma'am has already shed light on Arjun Khotkar judgment, so I don't need to delve into it. Present position is that certificate under section 63(4) of BSA is mandatory. So in the last part of my presentation, I want to highlight that what the legal lacuna is in this, when the amount is frozen into different accounts, how do we get it back to the victim? So as I've already told that, so till now we have received 2000 complaints, and it is impossible to convert each and every complaint into FIR. So what happens is that in each in typical cyber fraud, cyber financial fraud, let's say it's an investment scam or digital arrest scam, the money goes into hundreds of bank accounts, and the system at central level, which is operated by MHA, there are a lot of banks also there. They freeze the money. They identify that this is the victim's money and it has gone to so and so account, and it has to be frozen there then and there. So that money is legally it's a victim's money. And that money can be reversed to the victim by only a court order. And the courts generally give order only when there is a FIR. So that is how the deadlock is there. Practically, it is not possible to have FIR in each and every complaint, but for victim to get his money back, there has to be an FIR. So a lot of states have reached to this via media, that they have made their internal mechanism in which this complaint is enough. Complaint that is recorded on National Cybercrime Reporting Portal. Now the new BNSS has the provision of EFIR. So we should ponder that whether we can treat that complaint as EFIR or not. That complaint itself becomes EFIR, because ultimately that is coming through electronic mode, and that is Cybercrime Division Police. So that EFIR should be enough, and we should not insist upon the regular FIR under 173. So that is the problem. Complaint of cyber financial fraud reporting, National Cybercrime Reporting Portal. This is done. Then we give notices to bank to give us the information that how much money is a victim is there. Registration of FIR, holding of fraud amount in accused account, request to the court by the complainant to release the money. So ultimately, if my money is frozen, I receive a message. Let's say if I was a victim of 10 lakh of cyber fraud, I get a message from MHA that 1 lakh of your fraud money has been frozen into some bank account number. They generally give 5 digits of that account number so that you are able to identify the bank account number. Then the victim goes to IO. That, sir, I have received this message. How can I get this money back? So IO says that you should apply to the court. Court only can direct the bank. Then the complainant goes to court. Court asks for say of IO. But sometimes say of that we don't even reach to that stage because FIR is not there. And then that matter is dismissed there and then and there. So that is the problem. Court is to release. Challenges faced, requirement of registration of FIR in all cases, delay in court order. So the problem is that any mule account, any account that has the victim's money, it has money of 10 victims, not just one victim's money. It has five of it can be any number. I'm just giving as an example. It might have money of 10 victims. Then whoever goes to court first and whoever goes to who can claim the money first, the bank will release it to them. So it's a first come first serve basis. So if we take a lot of time, then the victim from will not be able to get that money. So that is the problem. If we are stuck in this loop that we have to take the say of IO, we have to take the say of the account holder also. So now judges are sometimes asking for the say of the account holder that is in Madhya Pradesh or Jharkhand. That fraud account holder, their say is also being taken. So that takes a lot of time and he will never come. And the victim's money, he will never get back this money. So this is the real problem. We should do something about it. Release of first gets it. So a lot of Gujarat has evolved this model that they are giving this money back through Lok Adalats. They have weekly Lok Adalat. They don't insist on FIR. They have made for the performer that complainant victim can apply for the release of money in this performer. They have pre-fill performer for the sake of the IO, that I just have to do this formality, and they have pre-fill performer for the court order, Lok Adalat's order. So they are disposing hundreds of applications in each session of Lok Adalat. So this is how effective coordination and efficient outlook can change the system. Otherwise, for problem, because after every cybercrime case that we crack, if you see the comments on social media, each and everyone will say, "Sir, so what? I will never get my money back. My account, my money is there. Some account given that money back to us." So the problem is because of this deadlock. So I would request this house to think about it. We have already given one presentation about it along with DPI, but there's still no resolution. FIR should not be mandatory amount, speedy disposal of financial fraud cases, an automated process to be completed in time-bound manner. And this is the solution. So with this, I conclude. Can ask questions if you want. Thank you. Karnataka High Court's order is there. Himachal High Court's order. They are doing it, no? That EFIR, this complaint is admissible, ना? आप एक बार माइक लेके बोलिए ना मैडम.
I think you had Karnataka High Court order, correct?
हाँ हमारे पास है. I'll share.
That we had tried here, no? In
अच्छा.
Goa, also one court, one judge had.
हाँ, so
We'll have question answers. Yes, after the, yes.
That's why, because he was not mentioning.
Moving on to the second presentation, which is by Mr. Kulbhushan Gupta. A little about our speaker. He is a scientific assistant, MSc Forensic Science, worked 4.5 years in Delhi State Forensic Laboratory, started working in Goa FSL since October 2017, visited more than 800 crime scenes, at present reporting cases of Computer Forensic Division and Forensic Ballistic Division. Mr. Gupta, please come on stage.
Good evening, honorable judges, public prosecutors, and all the officers. So, in this session, I will be discussing about forensic investigation of electronic evidence and cybercrime. In Goa Forensic Science Laboratory, we have well-equipped cyber forensic division. So in this cyber forensic division, we receive various types of digital evidences from various law enforcement agencies, and that digital evidences are mobile phones, memory cards, pen drive, DVR, NVR, and we do examination of these evidences in forensically sound manner and submit the report, and we give the report to submit the same in honorable court. And we are 79A certified laboratory. In India, very few forensic science laboratories are certified under this 79A. Yes, so our computer forensic division of Goa State Forensic Science Laboratory is 79A certified. So this 79A of IT Act, it empowers the government to designate bodies as examiner of electronic evidence to provide expert opinions on the electronic evidences, which are crucial for authenticating digital evidences. So these are the importance of 79A certificate. It gives advantage to the examiner of digital evidence. It ensures authenticity, it establishes reliability, and facilitates admissibility to report the submit by the digital examiners. So, what is cybercrime? Cybercrime is already covered by our previous speaker. So, any illegal activity which involves the computer, internet, network, or any other communication devices comes under the purview of cybercrime. These are the different type of cybercrimes like cyber stalking, cyberbullying, pornography, child pornography, impersonation, phishing, vishing. This scheming, I would like to explain. In scheming, in this cybercrime, fraudster, they obtain the information, card information, by attaching the unauthorized device to the ATM or POS machine. So here in that image, they can you can see that on schemer is there. So with the help of schemer, they can clone the information present on the ATM card, and they also attach one hidden camera in one camera. With the help of that hidden camera, they can record the security pin of ATM card. These are another type of cybercrime. So these all type of cyber crimes, it involves the use of either computer system or mobile phone as a target or means of committing cyber crime. So these all type of digital evidences are used in digital forensic to get evidences from them. So digital forensic is defined by NIST, that is National Institute of Standard and Technology. Forensic science itself is a applied science. In forensic science, we use applications of other branches of science for the purpose of legal justice system. So in digital forensic, we use the knowledge of computer science and information technology. So according to NIST, digital forensic is a branch of forensic science which involves the process of identifying, acquiring, preserving, analyzing, and reporting of digital evidence in a manner that is legally admissible. So in digital forensic, we deal with the digital evidences. So under the 79 ITF, digital evidence is defined according to that any information that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phone, and digital fax machines are comes under digital evidence. So the main feature of digital evidence is that it can be transmitted beyond the borders. And digital evidence are highly fragile in nature. It can be easily altered, damaged, or destroyed. So special precautions should be taken while collecting the digital evidences. So, according to nature, digital evidence are categorized in two parts, that is volatile evidence and non-volatile evidence. So, in case of volatile evidence, it remains in the digital media till it is powered on. Like RAM is the best example of this volatile digital evidence. So, if a computer system is on and we are performing any task and we have not saved the task, so it will be there. And when we switch off the computer and if we do not save that task, so we may lose that data. So if any computer system is present at scene of crime and we want to get and we have to get that data, so we can acquire that data using RAM dump. So various softwares are available for this. Belkasoft and forensic toolkits. With the help of this software, we can acquire the RAM dump, that is live data. Okay, so in the case of non-volatile, it remains in the digital media even after the device is powered off, even after the power is removed. So example of this non-volatile evidences are hard disk drive, pen drive, CD, etc. So for the purpose of study, analysis of digital evidences and research, the digital forensics are categorized in these different branches. So these branches are mobile forensic, computer forensic, IoT, that is Internet of Things. Under this IoT, we do examination of various types of sensor, smartwatch. In the CCTV forensic, we do examination of DVR, NVR, and various types of standalone CCTV cameras, drone forensic and cloud forensic. So we'll discuss this about these evidences and branches of digital forensic in further slides. So these are the different type of digital evidences. So during collection of digital evidence, we follow these procedures like initial assessment. First, we have to identify the evidence, then documentation, photography of evidence, then we have to we note down the serial number, IMEI number, and all the information of that digital evidence, then securing the evidence, data collection, and data integrity. Data integrity is very important. We maintain the integrity of data by calculating the hash value. So in mobile forensic, we do examination of smartphones, SIM cards, memory cards. So nowadays, almost every person is having a mobile phone. So mobile phones have become a primary source of digital evidences. So this type of information we can get through mobile phone. So these informations are very useful for the purpose of, in any crime. So like I would like to share some case study on the basis of these different informations which are resides on the mobile phone. So like in one case, in one case, four persons were having a party. So अचानक उनके बीच किसी बात को लेके लड़ाई हो गई. So the three person they together killed the fourth one. So when they were having party, they clicked the selfie. So उन्होंने जो selfie लिया, in that selfie, when we got that mobile phone for data extraction, we extracted all the data from mobile phone, and when we analyzed that image file, we got the longitude and latitude of that location. Even in that selfie, the model of mobile phone was there, timestamp was there. So all the information we got in that case. So in another case, like इनके install applications. So आपने सुना होगा in so in one case, accused person and later victim lady disclosed some of her private information with that accused person. Later that accused person started the blackmailing the victim lady, and he also installed one spyware in her mobile phone, and he got access of her mobile phone. So after installing that spyware, उसके पास विक्टिम लेडी की सारी इंफॉर्मेशन उसके पास आने लगी और वो उसको ब्लैकमेल करना स्टार्ट कर दिया. So when we got submission, we extracted data. So in the case of spyware, जब भी हम कभी spyware मोबाइल फोन इंस्टॉल करते हैं, so ये spyware शॉर्टकट क्रिएट ये जो शॉर्टकट क्रिएट हो जाता है लिस्ट ऑफ एप्लीकेशंस. तो जैसे इस शॉर्टकट को हम आइडेंटिफाई नहीं कर सकते. सो व्हेन वी एक्सट्रैक्टेड डेटा, वी गॉट दैट स्पाईवेयर. Faraday bag, we use Faraday bag to isolate the mobile phone from network. So if in a mobile phone, if you use a physical SIM card, so if we have to isolate that mobile phone from network, so we can easily remove the SIM card. Okay, so that mobile phone will be out of network. But in case of password protected mobile phone, and if that mobile phone is having eSIM card, in that case, that Faraday bag is very useful, because if mobile phone is password protected, so we cannot switch off that mobile phone, and eSIM is there, so we cannot we cannot isolate the mobile phone from network. So Faraday bag is very useful in that case. These are the different type of mobile operating systems. So to recover data from mobile phone, we have three tools, that is GFET4PC, Mobile Edit Forensic, and .xry. So with the help of these tools, we can recover all type of data from the so these are the doing the extraction of mobile phones, like manual extraction. Second one is logical extraction. Using this method, logical extraction, we can recover the data available on the mobile phone. One more method is there physical extraction. So with the help of that physical extraction, we can recover deleted data also from the mobile phone. As we go from bottom to top in this extraction process becomes more technical, and it becomes more invasive. So in case of broken mobile phone, like if mobile phone is broken, but chip of that mobile phone is intact. So in that case, we can go for the chip of we can remove the chip of mobile phone, and with the help of adapter and software, we can recover the data from that broken mobile phone, chip of broken mobile phone. So whenever we recover any data, so get one system generated data. So this system contains all information of device, and and all the artifacts what we have extracted from the mobile phone. So here, left side, you can see the information of device, that chipset of mobile phone, IMEI number, model, serial number, ICC ID number, and on the right side, you can see the various uh, contents of mobile phone. In red color brackets, there are some data which is deleted, we could recover. This is a report of another that is see. This also contains all the information. This is another tool, a report of XRY. So whenever we submit any report, we also give a soft copy of this report along with the extracted data. Okay, this is a SIM card. It's if we got any physical SIM card, so we can also get data from SMS messages. So if you might have noticed that there are numbers are mentioned in the SIM card. So if we decode that number is called ICC ID, integrated circuit card ID. So when we decode that number, we get these informations. Like first two digit of that ICC ID number depicts the major industry identifier, like network operator of that SIM card, whether it belongs to Geo, Idea, or any other network. And the next two digit is a country code. So another after that two digits are issuer identifier number. So we can get this information by decoding the numbers printed on the SIM card. In case of memory card, we get this type of information: call logs, saved contacts. So in CCTV forensic, we do examination of DVR, NVR, and different type of standalone devices. So DVR stands for digital video recorder. So DVR and NVR is the devices which used to store and record the images and videos. Images and videos are recorded by CCTV camera. There is a basic difference in case in CCTV and in NVR and DVR. In NVR, we use IP camera, and in DVR, we use analog camera. So IP camera record the images and video, and it process the video itself. But in case of DVR, that analog camera, it records the video, and later it sends the signals to DVR, and in DVR it convert into readable format. So in NVR is more efficient than DVR. So in case in DVR, this type of hard disks are used as a storage device. So we can differentiate between DVR and NVR. Like left hand side, we have image of DVR. So in DVR, in NVR we use Ethernet cable, and in DVR we use. So whenever we see any NVR for analysis, first we make a clone or image of the original hard disk. So for imaging this type of images, like Folgan Logic Cube, OpenText TX1, and Super Imager, and after making a clone original hard disk, we extract the relevant data with the help of software, that is video investigation table. We frequently use terms like imaging and cloning. So when we say imaging, talk about imaging, so imaging is a compressed file of the entire drive, while cloning is the exact copy of the drive. So this is the common questions asked by IO, that how many days of footage can a CCTV hard drive record, hard drive store. So it depends on the recording quality and number of cameras connected to the DVR. So this is a rough estimate, like if four number of cameras are connected to DVR, and if 1 TB of hard disk is connected to DVR, so approximate 10 to 12 days of footage can be recorded. So these are the different formats of videos stored in DVR, .bav, .mp4. Generally, the DVR or NVR, in DVR and NVR, they use format to store the videos. So to so this type of these videos having this type of like BAV.ASF and H.2X4. This type of video cannot be played in all the players. So these are the list of players like a smart player. So we give these players along with the extracted data so that it can be easily played in the court. So when the data from DVR or NVR, so we use the system generated report, and the system generated it contains information of DVR and and the hard disk. And right hand side you can see the report also contains the file name, file type, type of file, whether it is overwritten, normal, or deleted file, and it also includes the hash value of the each individual file. So in computer forensic, these are the storage devices, a hard disk drive, RAM, SSD, and some standalone devices, pen drive, CD, digital camera, in memory card of digital camera. So these two softwares are used to recover the data from these in case of disk forensic or computer forensic. So this is a one workstation. In this workstation, so whenever we have this type of evidences, we always connect the evidence in the right protected bin. So drone forensic, in drone forensic, we can we recover the data. We do the examination of drones and we recover the data from it. So these are the major components of drone: physical component and softwares. So these are the informations that can be obtained from drones. We can recover multimedia files, registered email accounts, update history, flight logs like flight details we can also and from so these are details we can get from the drone. So integrity of retrieved data, whenever we recover data with the help of softwares, we calculate the hash value along with it. So data integrity is process of keeping data accurate, complete, and secure. So these are the different hash algorithm we use: SHA-256, SHA-1, SHA-2, and MD5. These are the hash value. Whenever we calculate hash value is the combination of alpha. So whenever we calculate hash value of any file, we get path of that file also. These are the different softwares from which we can calculate hash value. These are the thank you.
Thank you, Mr. Gupta, for your very informative presentation. If I can request the team to kindly put together 3 chairs on the stage for a question and answer session. We've covered a lot of ground today, and it's now time for your questions. To moderate the same, if I could request Honorable Shri Justice Ashish S. Chavan to do the honors, please come on stage. I also request our 2 speakers to be seated on the stage along with Justice Chavan.
I know we are pressed for time, but I'll try to wrap this up quickly. Basically, we saw a very, very interesting combination of two very erudite and enlightened gentlemen who spoke to us about two very interesting facets of what I would call as two wings of the justice delivery system. So, the justice delivery system typically consists of judges, lawyers on one hand, and investigating machinery and the scientific analysis or scientists on the other hand. So it was a wonderful combination of uh, uh, very insightful things that we learned today in terms of investigating agency being uh, very, very forthright and very, very categorical about how they go about conducting their investigation so far as digital forensics is concerned. And from the scientific perspective, we also got a very enlightening approach as to how this entire digital evidence and forensic science is being conducted at that level. So, a couple of not exactly a summation, but a couple of takeaway thoughts that I had jotted down. One was a very interesting aspect of Section 27 being applied for retrieval of data from cloud storage. I think this is a very, very interesting topic for lawyers as well as us judges also to look at and to ponder about how this can be made much more efficient. Then the discussion about the erstwhile 65B certificate, the new conundrum posed by 63, section 63 of BSA, especially when it talks of the latter part where the certificate has to be authenticated by an expert. Who is that expert? Various gray areas are there. But then again, in every new act, there is also always some kind of a bridging that requires to be done. And that bridging comes by way of interpretation of areas which are legal challenges which come up before the courts. And then courts try to bridge the gap and try to offer some kind of a synergetical solution to it. We also saw a very interesting slide, and I couldn't help noticing the top, the title of that slide. It said, "Devil lies in the details." Indeed, devil lies in the details, and this couldn't be more true in the aspect of digital forensics and digital evidence. Yes, we had a very interesting question thrown up by the first speaker, who's a very senior police officer. And that question was, what does one do about the recovery of monies which are byproducts of financial fraud? And it does require a lot of wondering about. But the one angle, as I could think immediately, of course, may not be a long-term solution, is registration of EFIRs, because BSA does contemplate registration of EFIRs, which does not take much time, and because the starting point of any investigation is the registration of FIR, therefore perhaps many courts have held that it is mandatory, and there must be some kind of solution found for it. The second speaker was also equally erudite and scholarly in his presentation. We understood what is digital evidence from him, what is digital forensics, how digital evidence is collected, and more importantly, how mobile forensics is being conducted. Summing up, I can say that between the justice delivery system, the investigation machinery, and scientific analysis, what we are seeing, what we are witnessing is a synergy, and that is what is required. Rather than these three areas being watertight compartments which do not communicate to each other or perhaps perceive each other as being independent. There's a very welcome thing that I have witnessed today, and we will keep witnessing in the future, which is the synergy between these three different parts. I would end by saying Darwin's theory of evolution speaks about struggle for existence
and survival of the fittest. Now, the analogy that I'm trying to draw here is whenever there is any kind of a synergetic approach towards various things, like for example, here you have between scientific analysis, justice delivery system, and the investigating machinery. There is always bound to be evolution. And in that evolution churning process, the struggle for survival of the fittest laws, the laws which can adapt most to the situations which are required, and ultimately those that are fittest will survive. So with that, I'll come to an end, but I can't, end with sharing a very interesting fact about a cyber crime which I had read. And this was something which happened in, I think, in some part, some country of Europe. And this was concerning a child pornography case where a child pornographer, and this was, I had read this almost 6-7 years ago. And I can now relate to it today when I was sitting here and listening to all of this. What had happened was this person was indulging in child pornography, also in child exploitation and trafficking, and he had a lot of data in the form of videos and digital and photographs and all of that stored in a hard disk drive. Now, very interestingly, he had this a room where he used to do all these activities. The door of that room, just as we can see a door here, it had electromagnetic fields installed into it. So when the raid happened and the investigating officer seized all the data and they took out of that particular door, the electromagnetic field interrupted the entire data, corrupted it. So the moment the the hard disk went out of the room, it was empty. So it left a lasting impression on my mind when I read it, and now I can relate to all of this, today also. So thank you so much. Both these speakers have been really enlightening, and I can throw open the field for a few questions. I'm quite sure we are pressed for time again, but then again we can accommodate a few questions. The organizers will let me know to stop, of course.
Okay, my first question is an actual practical question. This is from the civil law side. What you've actually presented is the criminal law side. Now, the 63 clause 4 certificate, which is at part B, is an expert. What you've spoken of is of an institution which is 79A certified only, which has a right to grant that certificate. The hash value which you've shown generated is no online tool. It is in PowerShell itself, which any of us can generate. My problem is if we generate it also in that SHA1, SHA256 or MD5 also in that, and we dump the thing into text and we produce the hash value. Now, because here in Goa, we don't have any other 79A certified organizations. If for the time being till they certify who's supposed to be the expert, suppose we get the certificate from a computer technician who's witnessed us doing this process, would it serve the stopgap?
Yeah, I think so. It should serve the purpose. As long as those as long as court accepts, there should not be an issue.
See, we don't have to go to the extent of write blocker and all these things, right? Because we have to just go to the original source of the device, the actual device connected to our computer, go to the actual file drive and generate the file hash.
Hash value changes.
No, so the hash value, whatever it is in the original source, whether it is copied over once, twice, thrice, remains the same. That is what the purpose of.
Yes, in case of hard disk or I spoke about that disk forensic. So in that case, we use write blocker. But in case of mobile phone, we cannot use write blocker. But if a person submits data, so along with that, he also submit that certificates or part A certificate. So we can consider this, I think.
That much should be enough. But
Yeah,
other
and,
expert, you can, as you mentioned, that any computer expert, you can have that also. We are trying to have a FSL expert as a being expert for the second part. We are moving some file regarding that.
Yeah.
Any other questions? Anyone online who wants to ask a question? How do they raise their hand? Digitally. Yes. Yes, madam.
My question is for FSL. If the DVR which is attached by you is secured by a password,
Yes.
how do you open it for extracting the data? And if such data is produced in the court and the court wants to open the DVR in the court to see what it is, it again comes that it is secured with a password. So how do we reconcile that when it was secured with a password, how did the expert open it? And how was it data was extracted? And if such data is extracted, is it mentioned in the report that it was secured with the, these all are gray areas which come during the trial. If you throw some light.
Yes, yes. In case of DVR, whenever we receive any DVR or NVR, first we make a clone copy of that hard disk, that is storage device of DVR, and the software we use, so it bypass that password. So we need not to break that password. Software itself bypass the software itself bypass that password, and we can extract the data without breaking the password in case of DVR or NVR. Similarly, in case of computer, like we protect our computer with the help of some PIN or password. So in that case also our software can bypass that password without tampering any data.
Otherwise, the question remains, if it is not mentioned in the report, the question remains, how is the expert opened it? In the report, it is never mentioned that you have used such a software to open. It was password protected. And the expert had used this software, created a clone copy, then used a software, opened, which bypassed that password. And then again, it is secured with a password, because that password, we don't have that in the code. When you open the DVR, the message comes that it is secured with password. So the code doesn't have that software to bypass that password. So if it is mentioned in the report, I think it would be much better for appreciating what has been done by the expert in the laboratory.
Yes,
Thank you.
Password is only required when we access the DVR. When we access the DVR, but we don't attach the DVR to our system, we connect the hard disk. So to get data from hard disk, password is not required. So हम ये नहीं जान सकते कि दैट वो डिवाइस पासवर्ड प्रोटेक्टेड है. लाइक इन केस ऑफ कंप्यूटर पासवर्ड प्रोटेक्टेड है, बट इन केस ऑफ कंप्यूटर और सीपीयू वी रिमूव द हार्ड डिस्क एंड वी attach that hard disk. So in that case, password is not required. So we do not examine the DVR. We do examination of that hard disk which contain the data. Yes.
What we have noticed is that the courts don't actually observe or watch the data on the hard disk itself.
Yes.
Often it is the clone that is made that comes to the PP's file or the IO gives to the PP. Now that essentially is the copy of the original.
Yes.
So the primary data is the hard disk.
Primary data is hard disk.
Open the primary device, the primary evidence. That's what is being asked.
So
When they don't have the software that you use in the code to bypass the
so it is not recommended to play that video from DVR. So whenever yes
heavy cross-examination happens.
yes
This is the real issue.
yes
And then this is what fails, the entire evidence fails that this.
Okay.
That is what,
But sir, the hash value was taken, chain of custody was made. Expert is open, he's given this hash value. So the system is certified, the expert can give. Yeah, that, yes.
it tells you that this is the data which was not lost, its integrity is maintained. But it doesn't tell you the process that was followed by the scientific experts.
Okay.
Open and close the data.
Maybe FSM can, yes, it can be done.
Yes. Sure, sure. Sir.
Any other question? Yes. At the back.
Good evening. So my question was pertaining to Section 27, the disclosure that we have mentioned. As we know that under Section 27, it's a very weak piece of evidence, and disclosure of any fact is what is admissible. So when there can be a forensic analysis of the digital record, how can we rely on a disclosure by the accused or whichever the case may be? How do you reconcile these two facts?
So, ma'am, as ma'am mentioned, previous the question that was asked, when something is password protected, how do we make it admissible? So then we have to rely on the accused's disclosure itself in front of the investigating officer that I myself opened a Facebook account, or I myself opened this computer on my iPhone, especially iPhone, because what we mentioned, we can pass a lot of passwords, but in iPhone we can bypass. So in that case, we should have this 20 Act procedure that we draw a panchnama and we the accused sit with the IO and he opens his iPhone, then he downloads then he makes a copy file which is attached to his device, and then it is shown as recovery in the case, and then we get first for the examination. It was to the case. I would say he had sent out 3 people. It was cyber stalking case, cyber case, and he had sent an email. How do we recover that email? We can ask for logs from Gmail or Google. This person's device was used. What was the actual email that he had sent? So that complainant also brings with him, along with his complaint, that is not that strong evidence. If we recover the same email from his device, from the accused device, that is a very strong piece of evidence. For that, if it is a password protected, then disclosure, and also we can send the CD hard disk, as you mentioned, we can send hard disk also to FSL. If FSL is identified that hard disk. So both the things will help, obviously. So whatever we can, based on the case, we should do.
Is there anyone online who would like to ask any questions?
Yes, Mr. Gupta. Hello, am I audible?
Yes, you're audible.
Yes, my question is this: in case you receive a complaint under Corruption Act that so and so has paid the bribe by sharing a key of a cryptocurrency, how you will go about it?
Sir, if you could please repeat your question. Sir, kindly repeat your question, sir.
Yes. If in a corruption case comes before you that money has been transferred through cryptocurrency by sharing just a pass key, then how you will go about?
So crypto wallets give information. So all these crypto wallets which are used generally by CX, they are also on they are listed on FIU. And if the cryptocurrency is transferred by using the key or unauthorized use of private key, and we can get the information about the transactions which was made. And this intermediaries, they have to give us the KYC details and the IP logs which are used to transfer that money. And that IP logs can ultimately lead us to the actual person who made this transaction. And the KYC details also, sometimes if they are not fictitious, they can also help us to identify the culprit. Then we can have analysis of the trail of the money. That also can give us a lot of clues. And ultimately, if we are able to identify the accused, we can seize the mobile phone on which this transaction was being done. And that mobile phone will give us access to the crypto wallet and all the transactions which were done in the past and whatever information is available on that crypto wallet. So that will become an admissible evidence in this case.
Hello, sir. Audible. Mr. Rahul, sir, I would like to ask you one question that regarding websites are concerned, how we know that this website is genuine or a duplicate? Regarding one neighbor was he had circulating on WhatsApp one apps wherein it says that you can register your birth certificate and Aadhaar card and PAN card. So I said that so this is all fake website. So fake apps have been circulated on WhatsApp, but how we know that is website is fake or genuine?
So, madam, there are many tools available in the market in which you can copy paste that website and it will tell you that whether it is likelihood of that website being fake or genuine. We ourselves, Goa Police developed a tool that is called Spot the Scam. If you just type on your browser spotthescam.in, on that website you can type that URL and you can see it will give you a score of genuinity based on there are a lot of parameters that domain name, the website domain name has to be registered, when it was registered, what is the quality of the content in the website. Generally fraud websites use a low quality content. They have some grammatical errors, they have low quality images, and they don't have information about the actual person who are operating that website. So there are a lot of shady areas. Those are indicator. But even if a person is not using such platform, by looking at the website's address, that URL is there.
Yes.
So that also can give you a lot of clues that generally genuine platforms will have simple website sbi.co.in, sbi.co. Goa Police citizen.goapolice.gov.in. Very simple website. Domain name registered. It's very simple and very unique. If somebody has Goa Police services.in, something like that. So then it is an indicator that you should recheck this website and you should contact the actual person who might be operating that website. And then you can ascertain the genuinity of that website.
And HTTPS it comes usually,
Yeah,
or
but that is not necessary. That sometimes
is valid or genuine.
yeah, that also is an indicator.
Yes.
That is one of the parameter, but that is not the actual only parameter, because a lot of fake website I've seen that they have valid HTTP certificate.
Yes.
They take all the certification. They have valid domain name also.
Okay.
But when you look at the content, when you look at the contact number, then you will get the idea. You'll have to very deeply, because all these hotel websites.
Yes.
If I show you two websites of St. Regis, actual website and the fake website, it is very difficult to ascertain which one is genuine, which is
Exactly.
yeah. So a lot of platforms are there through which it can be.
Thank you.
Thank you for your questions, everyone. Speakers and justice, please be where you are. As a token of love and appreciation, GSLA would like to present mementos to the speakers, Shri Rahul Gupta, Shri Kulbhushan Gupta. If Justice Chavan will please do the honors. Last but not the least, one more person, Mr. Ashutosh Apte, Director, Goa State Forensic Science Laboratory, who has helped us a lot in organizing this series of workshop. Please come on stage, sir. Justice Chavan and speakers, kindly take your seats with the audience. And like all good things come to an end, so is day one of the workshop, requesting Senior Advocate Coel Pereira to please propose the vote of thanks. Mic is not working. You want me to hold it for you?
No, no. Give me. As a co-host of today's function, on behalf of the Goa State Legal Services Authority, here I am to do my assigned duty of giving a vote of thanks, which I hereby do to give finality to this thought-provoking function today. My sincere thanks to the Administrative Judge of the High Court of Bombay at Goa, Honorable Mrs. Justice Bharati Dangre, here present, and the judges of this Honorable Court, Mr. Justice Chavan, Mr. Justice Sriram Shirsat, and the speakers of today, Mr. Raul Gupta, Superintendent of Police North Goa, Mr. Kulbhushan Gupta, Scientific Assistant of Forensic Science, who in a very sublime and linear manner have respectively explained to us, all present here, the practical aspects and intricacies of handling forensic evidence and cyber crimes. This, to many of us, is a new subject which needed to be adverted to, and therefore the Goa State Legal Services Authority and the Goa High Court Bar Association put our hands together to organize this program. Our sincere thanks to the members of the district judiciary here present and who attended it virtually. Further, to the Director of Prosecution, the Inspector General of Police, and the Inspectors of Police attending virtually. To Mr. Ashutosh Apte, Director of the Goa State Forensic Science Laboratory, who we must acknowledge as being one of the key persons in organizing this workshop. The members of the Goa High Court Bar Association present physically and virtually, the presidents and members of the Bar Associations of North and South Goa, to the media persons, to the technical team of the High Court of Bombay at Goa, and last but not least, to Mr. Justice Valmiki Menezes and Mrs. Shabnam Sheikh for taking all the pains to ensure that this event was a success. Thank you all, and be ready for our forthcoming events in the offing. Thank you.